Okay, let's unpack this. Today, we are deep diving into the career of Professor David Feldman, KC, Holland, FBA, FRSA. Now, he's a legal figure whose path to the top, well, it fundamentally challenges the traditional notion of legal authority.
It really does, because when most of us think about who shapes the law, we picture courtroom titans, right?
Hmm,
Litigators rising through decades of intense advocacy, winning those landmark cases.
exactly, the courtroom stars.
Precisely. But Feldman's trajectory is, well, it's unique. His entire career fused the ivory tower of the academic world, teaching, writing, pure research with the highest levels of governance.
Including parliamentary advice and sitting on the high bench of an international constitutional court. That's quite the mix.
It is. And he's known, genuinely known, for having shaped the development of civil liberties and human rights law in the United Kingdom. But not through pleadings, not through arguing cases.
No, through intellectual rigor. It's fascinating.
Mm-hmm. It's the ultimate academic authority, in a way. The person who never actually practices the law in the conventional sense, but ends up helping define what the law is.
Right. And our sources here, they detail a truly rich biographical profile. They sketch out the life of someone who achieved high judicial office, advised Parliament.
All without ever needing to complete the bar course or enter legal practice. That's the standout point.
That's our deep dive mission then, to trace his journey. From, believe it or not, a student captivated by courtroom drama.
Terry Mason, apparently.
Right. All the way to becoming the Emeritus Rouse Professor of English Law at Cambridge and an international judge. We need to understand exactly how that pure scholarly work translated, directly into profound real-world political and judicial impact.
We're looking at a case study, really, how deep theoretical knowledge becomes powerful institutional capital. It's quite a story.
So let's begin where all great journeys start, with a learner, someone driven by curiosity. David John Feldman, born in Brighton, Hove. Grandson of immigrants from Eastern Europe, which gives it that classic aspiration story context, doesn't it?
It does. And his early education, like for many people, gave him his first taste of the law. But it wasn't some dry textbook that motivated him initially. He went to Brighton Hove and Sussex Sixth Form College.
Okay.
And his initial attraction to law, overriding his interest in history, was explicitly influenced by, childhood admiration for dramatic courtroom figures.
Ah, okay. So we're talking about the titans of legal theater. Marshall Hall, known for his dramatic flair, and maybe more popularly, the fictional defense attorney, Perry Mason.
Exactly those two.
That's a fascinating insight, though, isn't it? Because those figures, they embody not just the rules of law, but the drama, the process, the tension between state power and individual rights.
Absolutely. And that curiosity, fueled by narrative, by the spectacle of justice, it eventually led him toward academic rigor. But his path wasn't, a straight shot to success, which provides an important lesson, I think, for anyone facing career setbacks.
Right. We see that initial hurdle quite early on. His first attempt to secure a university place actually hit a snag, an unsuccessful application to read law and history at the University of Bristol.
Mm-hmm. Must have been disheartening, but it led to a critical strategic adjustment, a really key bit of advice.
It did. He was advised, apparently, that confining his application just to one subject, just law, would significantly improve his chances.
Which it did. So this minor hurdle, it resulted in a more focused academic approach. And that led to acceptance at Oxford, where he really thrived.
And thrive he did. He graduated in 1976 with a first-class honors BA in jurisprudence from Exeter College, Oxford. It's top tier.
And he cemented his academic foundation there, too, subsequently receiving both a first-class honors BCL Bachelor of Civil Law and his DCL, the Doctorate of Civil Law, also from Exeter College.
Wow, okay, so a very strong Oxford grounding.
Hugely strong. And his time at Oxford was pivotal, particularly his studies under Stephen Cretney, who would later become a dean at the University of Bristol, funnily enough.
The Bristol connection again.
Yes. And Cretney played a direct advisory role in what has to be the most critical decision of Feldman's career, the big pivot away from traditional practice.
This is the moment, isn't it? The one that defined everything. Because many ambitious first-class Oxford law graduates, they feel immense pressure, right? Societal, institutional pressure.
To pass the bar, enter pupillage, start practicing, gain that real-world credibility.
Exactly. Yet, in 1976, straight out of Oxford, he chose a completely different route.
He had the opportunity to pursue the conventional track, but Cretney advised him about an available lectureship in law at the University of Bristol, and Feldman made the, frankly, highly unorthodox choice to accept that lectureship instead of completing the bar course.
Wait, hang on. Isn't that a massive risk? Choosing pure theory teaching over the bar course. Didn't that limit his influence initially? How did he overcome that practical credibility gap that many practitioners often hold over academics?
Well, it was a huge risk, definitely. But the answer, I think, lies in the sheer quality of the scholarship that followed. What's fascinating here is that the foundation of his subsequent judicial and advisory career was rooted purely in teaching and theoretical law from the very beginning.
So he didn't try to bridge the gap with practice.
No, he didn't try to overcome it with practical experience in the usual sense. He sort of sidestepped it entirely by building an authority based on deep, abstract, and comparative knowledge. And arguably, that kind of knowledge is more potent when you're dealing with fundamental constitutional issues than, say, daily court procedure.
Okay, so he was building his legal authority in the lecture hall in the library, essentially.
Pretty much. His initial choice set the stage for a unique kind of judicial and academic authority. He proved that profound legal theory can itself be a form of powerful practice, if you like.
And once he made that commitment to academia, his career accelerated quickly, didn't it? Yeah. Crossing some of the UK's most prestigious law schools.
Right. So now we move into his academic ascendancy, and we see rapid, significant progression starting, as we said, at Bristol. He started there as a lecturer in 1976.
Okay.
And within that period, his work on public law, civil liberties, it clearly stood out because that led to his appointment as reader in law in 1989.
Reader, that's a significant step up from lecturer.
It is. It shows he was already establishing himself as a leading voice in his field quite early on.
And he was already building that crucial global scholarly footprint even while at Bristol. Because that same year, 1989, he secured a prestigious visiting fellowship at the Australian National University.
Good point. So that established him as an international commodity, you could say, even before reaching the full professorial ranks in the UK.
Then came the move in 1992. He was appointed the Barber Professor of Jurisprudence at the University of Birmingham.
Right. Professorships are a significant elevation. It signals national recognition of intellectual leadership. But he wasn't just a researcher there. He took on substantial institutional administration, too.
Ah, yes. He served concurrently as Dean of the Faculty of Law from 1997 to 2000.
That is a critical point, because it shows he wasn't simply an isolated thinker locked away with books. Being a dean requires practical skill, political nous, managerial ability.
But how challenging was that, do you think? Balancing that deep, sometimes isolated work of constitutional theory with the very time-intensive demands of steering a massive faculty. Wasn't there a tension between the ivory tower and the administrator's desk?
Oh, I'm sure there's always tension, but it speaks to his capacity for synthesis, perhaps. Legal scholarship often requires understanding the practical application of ideas anyway, and managing a law faculty ensures constant exposure to the current pressures facing legal education, the profession.
True. Keeps you grounded in a way.
Exactly. This administrative experience undoubtedly sharpened his capacity to engage with the complexity of public service later on, no question.
His academic pinnacle then came in 2004. Appointed the Rouse Professor of English Law at the University of Cambridge, and simultaneously became a Fellow of Downing College. Now, that title carries immense historical and legal weight, doesn't it?
It really does. The Rouse Professorship is one of the most distinguished historic chairs in English law, named after the Cambridge mathematician and academic W. Rouse. It's a position of tremendous authority within the common law world. Accepting this chair placed him firmly among the highest echelon of legal historians and theoreticians.
And his leadership continued at Cambridge. He wasn't just appointed to a prestigious chair, he was tasked with steering the academic direction of major institutions again. From 2006 to 2009, he was chairman of the Faculty Board of Law at Cambridge.
And even more impressively, perhaps, later on, from 2013 to 2016, he served as chairman of the massive Faculty of Human, Social, and Political Science, HSPS, at Cambridge.
Wow, HSPS. That's huge.
It is. Steering such a complex, multidisciplinary faculty, covering everything from anthropology to political science and sociology, it demonstrates his recognized capacity for intellectual leadership far beyond just his specific discipline of law.
He also led the broader legal scholarly community, serving as president of the Society of Legal Scholars from 2010 to 2011.
And just to loop back to that global academic reach, even during his time at Cambridge, he continued to take on senior honorary visiting fellowships. You mentioned the Australian one earlier, but there was also the Migunya Distinguished Visiting Fellowship at the University of Melbourne and the Sir John C. Smith Senior Visiting Scholarship at the University of Nottingham.
Right, so constantly engaging internationally.
He retired from the Rouse professorship on September 30th, 2018, now holds the title of Emeritus Professor. But his academic journey, impressive as it is really just the platform, isn't it? The platform for the central narrative of our deep dive, the moment theoretical scholarship became tangible legal power.
Yes. But the true test of all that theoretical groundwork, it came outside the university gates, didn't it?
Yeah.
How did Parliament, and eventually a fragile international court, come to rely on a professor who had never argued a case? This takes us to Section D bridging theory and governance.
This is the crux of it. The unique influence of Feldman. You have to remember the context. The UK legal landscape was fundamentally altered by the incorporation of the European Convention on Human Rights into domestic law. That was the Human Rights Act, 1998.
A massive constitutional shift.
Huge. And the government, Parliament, they needed experts who understood the theoretical underpinnings, the comparative international law, the constitutional implications, not just common law procedure. They needed the academics.
And we see this translation of theory into politics most clearly in his parliamentary service. From 2000 to 2004, he served as legal advisor to the Parliamentary Joint Select Committee on Human Rights, the JCHR.
Yes, and that committee's job is crucial. It scrutinizes every single piece of legislation for compliance with human rights.
So his role wasn't advising on, say, technical common law points?
No, not primarily. It was about foundational civil liberties, the constitutional framework governing the relationship between the state and the individual. His academic expertise directly informed Westminster's legislative process during that absolutely crucial period of human rights implementation in the UK.
And this wasn't limited to general human rights oversight either. Later, in 2011, he served as specialist advisor to another joint select committee. This one was on the detention of terrorist suspects, temporary extension bills.
Now think about the complexity, the sensitivity of that specific advisory role. This was the highly politically charged area where the state was attempting to extend detention limits, directly challenging civil liberties in the name of security.
A classic dilemma.
Exactly. And in such constitutionally challenging areas, the specialist academic's impartial theoretical opinion was deemed essential for legitimate legislative scrutiny. He was, in effect, the guy ensuring that political urgency didn't completely override constitutional principles.
Okay, that makes sense. But then comes the truly extraordinary jump, the international bench. This appointment, it raises the biggest question of our deep dive, I think. How does an academic become a high court judge in a politically charged post-conflict nation? We're talking about the Constitutional Court of Bosnia and Herzegovina.
This appointment, which began in 2002, it's the single most distinctive element of his career, no doubt about it. The Constitutional Court of Bosnia and Herzegovina is the second highest judicial authority in that nation, and it was established under the framework of the Dayton Agreement.
The peace treaty that ended the Bosnian War.
Correct. So this court is unlike any domestic UK court. It's a hybrid institution, designed specifically to maintain constitutional stability and, well, peace.
So why did they need a non-practicing academic from Cambridge to sit on it? What was the thinking there?
Well, the Dayton Agreement itself explicitly provided for the inclusion of 3 non-national judges, judges who were neither citizens of Bosnia nor any neighboring state.
Okay. Outsiders.
Yes. And they were to be appointed by the President of the European Court of Human Rights. This was done quite deliberately to ensure impartiality, to try and prevent the court from becoming polarized along ethnic or political lines, which was, of course, the whole reason for the conflict in the first place.
So he wasn't just a judge. He was effectively an international guarantor of the rule of law in a very fragile state.
Exactly that. And the unique distinction of his path was highlighted by commentators like David Clark. He observed that Professor David Feldman achieved high judicial office sitting on a constitutional court with the final say over the supreme law of the land.
Without ever having to venture into the practice of law beforehand.
Precisely. Which is an almost unheard of accomplishment in common law jurisdictions, right? Where judicial appointment usually demands years and years of advocacy experience.
His judicial appointment was initially expected to last 5 years, is that right?
Yes, but he served until 2010. Which demonstrates, I think, the necessity and effectiveness of his contribution in that incredibly difficult environment. Furthermore, he was elected vice president of the court from 2006 to 2009.
So he clearly made a significant impact there.
His work there profoundly influenced his own perspectives, too, by all accounts. If we connect this to the bigger picture, serving on a post-conflict constitutional court under the Dayton Agreement, well, It provided him with invaluable international and comparative experience. He wasn't applying established UK precedent. He was grappling with fundamental questions of statehood, sovereignty, human rights interpretation, constitutional stability.
In an environment where the Constitution was essentially the peace treaty itself.
Exactly. It was law at its most fundamental and arguably most consequential.
That is a completely different level of judicial responsibility. How did a scholar known for quite theoretical work on UK civil liberties, how did he transition to actually enforcing those rights in a system defined by political fragility and presumably very diverse legal traditions?
Well, I think it requires the very theoretical grounding he possessed. In Bosnia, the cases were often highly political. They revolved around the balance of power between different entities within the state, human rights protections for refugees, complex issues of property restitution, things like that.
Right. Not straightforward stuff.
Not at all. A traditional litigator might be excellent at interpreting common law statutes back home, but this court needed someone who could interpret a foundational document, the Constitution of Bosnia and Herzegovina, that had to serve as both a peace treaty and the supreme law of the land. That needs a different skill set.
So his deep theoretical grounding in jurisprudence, in comparative constitutionalism, that became the most vital tool, allowing him to approach the problems neutrally, systematically.
Far removed from the political baggage or, the common law specifics of daily practice back in the UK, he learned firsthand the limits and the power of judicial authority in these highly sensitive contexts. The experience solidified his authority as a public law theorist who also knew how to make binding constitutional decisions stick.
Which brings us nicely to his academic interests. This is where we see the intellectual wellspring, isn't it? The source of the ideas that allowed him to make these leaps into governance. His research was tightly focused on core areas of public life, synthesizing that early interest in state power and individual rights.
Yes. His core interests were pretty comprehensive: administrative law, civil liberties, human rights, and constitutional law, particularly, as we've noted, from an international and comparative perspective. His work really connects law, politics, and public administration. It examines how the state operates both internally and on the international stage, and how individual rights interact with that vast governmental power.
And it's explicitly noted, isn't it, that his scholarly publications since 2000 are the reason he's considered to have helped shape the development of civil liberties and human rights law in the UK.
That's right, which means his writing wasn't just, peer-reviewed academic work. It was authoritative enough to actually guide practitioners and influence judicial interpretation.
That is the highest form of academic impact, surely.
I'd say so. And we can trace this through his key publications. The most notable would certainly be his definitive text, Civil Liberties and Human Rights in England and Wales. The second edition came out in 2002.
What makes that specific text so foundational? Why did practitioners and judges rely on it so heavily, especially after the Human Rights Act came into force?
Well, before the Human Rights Act, civil liberties law in the UK was quite fragmented. It was drawn from disparate common law cases, various statutes. Feldman's work provided a comprehensive, structured framework. It basically codified the entire field.
I see.
So when the HRA 1998 incorporated the European Convention into domestic law, his text was perfectly positioned to synthesize that new convention-based rights framework with the existing common law tradition. It was essential reading for anyone trying to understand the new landscape. It provided the theoretical and historical context that the statutes alone just lacked.
It effectively became the authoritative map of the new legal territory. That makes sense. And if we look further back, we can tie his early work directly back to that Perry Mason inspiration we talked about, the interest in the mechanics of state investigation.
Absolutely. Remember that early curiosity about courtroom dramas. That interest matured into works defining the precise limits of state power. Like his text, The Law Relating to Entry, Search, and Seizure, published way back in 1986.
Right. Very practical application of rights theory.
Exactly. That book focused intensely on the interface between police powers and individual rights. The very procedural dramas that captivated him as a child, now subjected to rigorous legal analysis.
He also tackled criminal law specifics, like his work on criminal confiscation orders, the new law in 1988, shows his ability to apply constitutional principles to specific investigative tools. And he edited major collections too, like English Public Law in 2004, broadening his editorial influence.
The sheer breadth of his contributions is striking. The source materials mention he wrote or edited textbooks covering fields like corporate and commercial law, alongside his core specialty in public law.
Really? Corporate and commercial?
Yeah. which highlights his ability to synthesize diverse legal fields under a common framework, often informed by those constitutional and human rights principles. He was a prolific author and editor, ensuring his theoretical insights were codified and accessible to generations of students and practitioners across the legal spectrum.
That wide reach and profound impact. That's why his official recognitions are so significant, aren't they? Especially because they were granted without the typical career prerequisites of practice. Which brings us to Section F awards and final recognitions.
These formal honors from the state and the profession, they serve as the ultimate validation of that scholarly path he took. He was elected to the British Academy, the FBA, in 2006. That's one of the highest honors for a UK academic in the humanities and social sciences.
Huge achievement. He was also made an honorary bencher at Lincoln's Inn in 2003. Now, for listeners who might not be familiar with the Inns of Court, why is being an honorary bencher without ever being a practicing barrister such a huge statement in the UK legal world?
Well, the Inns of Court, Lincoln's Inn, Gray's Inn, Inner Temple, Middle Temple, they are the historical and traditional heart of the English bar. Benchers are the most senior members. They oversee the governance of the inn. Being made an honorary bencher as a non-practitioner, it signals an extraordinary level of intellectual acceptance by the traditional elite bar establishment.
So it's the establishment saying your contribution matters.
Exactly. It says that his theoretical contribution is deemed equal to or perhaps even greater than the contributions of some of the most accomplished career litigators. It's a massive validation.
But the most important recognition, the one that directly connects his academic interest to professional acclaim, was his appointment as Queen's Counsel Honoris Causa in 2008.
Yes. QC honoris causa. This title is reserved for those who have made a major contribution to the law of England and Wales outside practice. Its recognition usually reserved for top legal officials, judges, or, in very rare cases, scholars of immense stature.
So the QC designation, normally reserved for top trial lawyers, the SOCs, it was granted purely because his books and his advisory roles were that effective at shaping the law. How rare is that for a non-practitioner?
It is extremely rare, and the specific reason given for his appointment is incredibly telling. He was appointed QC honoris causa, and I quote, for his work in public law fields, particularly civil liberties and human rights.
Wow. Explicitly for his academic specialism.
Yes. His scholarly work was deemed an equivalent contribution to the public good as decades of high-level litigation. It is a powerful validation of that intellectual path he chose way back in 1976.
And finally, we have that wonderful, almost poetic full circle moment. It brings a perfect narrative conclusion to his early educational story. We mentioned that decades earlier, he was initially rejected from the University of Bristol when he applied to read law and history.
Yes, that initial frustrating rejection. Hard to imagine now.
Well, in 2013, the University of Bristol formally recognized his enormous contribution to law by awarding him the Doctor of Laws honoris causa.
Ah, fantastic.
The very university that initially rejected his mixed subject application decades prior formally recognized him as a foundational figure in British and international law. It's a fantastic narrative payoff, isn't it?
Right.
Proves that initial detours often lead to the greatest destinations.
Absolutely. A lovely touch.
So wrapping this up, what does this all mean? Our deep dive into the life of Professor David Feldman, it really confirms the viability and indeed the immense impact of a career built solely on scholarly rigor. He achieved this unique three-part career: world-renowned scholar, powerful parliamentary advisor, and international judge. He personifies the intersection where academic theory is translated directly into authoritative, real-world legal power.
And the core lesson here for you, the listener, I think it's about the nature of authority itself. Feldman demonstrated that deep theoretical understanding jurisprudence, comparative constitutionalism, detailed human rights analysis that can be the most potent tool for shaping policy and justice, especially in complex international settings like that post-conflict constitutional court in Bosnia under the Dayton Agreement.
His authority was intellectual.
It was, and that intellect allowed him to make global, tangible contributions to the rule of law.
He didn't need the traditional structure of the barrister, the courtroom battles, to establish legal truth. He wrote the frameworks that the courts now rely on to interpret and apply that truth.
Precisely. And that leads us to a final provocative thought. Something for you to explore on your own, building on this fusion of theory and practice. We've seen how Feldman's judicial work in Bosnia was crucial because he provided impartial constitutional analysis in a highly politicized environment defined by ethnic divisions, the aftermath of war.
Right. The need for neutrality was paramount.
Exactly. So, considering that international judicial appointments under peace agreements often require acute impartiality and political neutrality, what challenges might a scholar face when translating complex theoretical legal concepts like the deep nuances of civil liberties theory found in his books into binding, non-negotiable decisions in such a politically volatile environment?
Hmm. Is the theoretical ideal always compatible with the fragile political realities?
That's the question. Is the purity of the theory sometimes at odds with the messy compromises needed for governance in a post-conflict situation? That is something for you to mull over as you consider the true weight and maybe the inherent tensions of translating theory into power.